especially we are surrounded by laws. You cannot escape once you have violated these laws. No one is above the law of the Philippine territory. So what we are going to talk about today is criminal law and its process. Criminal law and its process. What is law? A law is a body of rules of conduct binding legal force and effect prescribed, recognized, and enforced by controlling authority. Law implies imposition by a sovereign authority and the obligation of obedience on the part of all subject to that authority. Laws are made by legislatures, where anyone who violated these laws must be held responsible. What is the highest law in the Philippines? The highest law in the Philippines is the Philippine Constitution. In Filipino translation, Saligang Batas ng Pilipinas, or we term it as Constitution ng Pilipinas. It is the constitution or supreme law of the Republic of the Philippines. What is really meant by constitution? A constitution is a written instrument by which the fundamental powers of government are established, limited, and defined, and by which these powers are distributed among several departments for their safe and useful exercise for the benefit of the body politic. It is the foundation of the system of government of the Philippines. Overview on how did the law evolve. The earliest law book was written about 2100 BC for Ornamo, king of Ur, a Middle Eastern city-state. Within 3 centuries, Hammurabi, king of Babylonian, had enumerated laws of privileged conduct, business and legal precedents, of which 282 articles have survived. The term eye for an eye, in Maxim, it is lextal units, or the equivalent value is found there as in drowning as punishment for adultery by a wife, while a husband could have slave concubines, and unequal treatment of the rich and the poor was codified here first. It took another 1,000 years before written law codes developed among the Greek city-states, particularly Athens and Israel. Eye for an eye is the principle that a person who has injured another person is to be penalized to a similar degree by the injured party. The principle of law of retaliation that a punishment inflicted should correspond in degree and kind to the offense of the wrongdoer as an eye, a tooth for a tooth. When someone is inflicted with an injury where Mr. Alpha mutilated the index finger of Mr. Bravo, then Mr. Alpha, his finger, specifically the index finger, must as well be mutilated as a consequence of his action. In a case where the monkey, the husband, or the male monkey rape the wife of Mr. Alpha, well, the Mr. Alpha will not also rape the wife of the monkey as an example of eye for an eye. Well, of course, that is not an example. We should not and we must not go beyond the context of this principle. What is Philippine criminal law? It is the branch of law which defines crimes, threats of their nature, and provides for their punishment. The body of law that defines offenses, regulates the apprehension, charging, and trial of suspected persons, and fixes penalties and modes of treatment applicable to convicted offenders. When someone is charged of a certain crime and found guilty by the competent court, the convicted person will serve the imposed sentence and pay the fine if there is any. What are the two foundations of the Philippine Penal Code? Actually, the old penal code, which is at present known as the revised penal code, is based on two prominent suppositions, namely classical and positivist theories. The following are the principles of classical and positivist theories relative to the code. Talk about the classical viewpoint of the penal code. First, the foremost principle of the penal code is that the basis of criminal liability is human free will, and the purpose of penalty is retribution. The theory of retribution holds that punishment is imposed on the blameworthy party in order for society to vent its anger toward and exact vengeance upon the criminal. In simplest terms, retribution depicts that when someone committed a crime must receive a punishment where he will put behind bars once proven guilty. Second one, to the classicists and the framers of the old penal code, man was essentially a moral creature which absolutely has a free will to choose between good and evil, thereby placing more stress upon the effect or result of the felonious act than upon the man, the criminal himself. The third one, they assert that man should only be adjudged and held accountable from wrongful acts so long as free will appears unimpaired. Then the fourth one, it has endeavored to establish a mechanical and direct proportion between crime and penalty. While the positivist viewpoint of the penal code, the positivist principle deviates from the classical school in connection with crime and with the criminal. The positivist holds that man is subdued occasionally by strange and morbid phenomena which constrains a man to do wrong in spite of or contrary to his volition. And then the second one, crime is essentially a social and natural phenomena, and as such it cannot be treated in check by the application of abstract principles of law and jurisprudence, nor by the imposition of a punishment fixed and determined a priori, but rather through the enforcement of individual measures in each particular case, after a thorough, personal, and individual examination conducted by a competent body of psychiatrists and social scientists. We have the characteristics of criminal law. First is the generality. Generality of criminal law provides that criminal law is binding on all persons who live or sojourn in the Philippine territory. The revised penal code applies to all persons who commit felonies in Philippine territory, regardless of nationality, gender, age, or other personal circumstances. However, we have the exemptions. Here are the following: treaties, stipulations, or execution agreements. Next, laws of preferential applications, followed by principles of public international law. The example are sovereigns, head of state, and persons with diplomatic status and immunity are not subject to the provision of RPC or the revised penal code. Consuls and consular. However, they are not exempt from local prosecution. Next characteristic is the territoriality. Territoriality of criminal law states that criminal law undertakes to punish crimes committed in the Philippine territory. The territoriality, the principle covers the what question or type of offense covered by the law. As a general rule, all offenses committed within the Philippine territory. However, there are also exemptions. The exemptions to the rule of territoriality are found in Article 2 of the Revised Penal Code, which provides for extraterritorial jurisdiction of our courts. Next characteristic is the prospectivity. Prospectivity concept of the criminal law provides that it cannot make an act punishable in a manner in which it was not punishable when committed, which is the ex post facto law. Thus, crimes are punished under the laws in force at the time of their commission. Under the prospectivity, the principle of prospectivity covers when laws applicable. As a general rule, the code has no retroactive. However, we have the exemptions. When the provisions would be favorable to the accused who is not habitual delinquent. Take note of the elements. It is favorable to the accused and he's not or she is not a habitual delinquent. Crime and law. No act is a crime unless it is so defined by statute. Criminal acts have both mental and physical elements, both of which must be present if the act to be considered a crime. In order for crime to occur, the accused must have committed the guilty act. It is the actus reus. And had the guilty mind of the criminal intent to commit the crime, which is the mens rea. On the legal perspective of crime, only conduct that the law specifically prohibit is a crime, which we term it as nollum crimen sine lege. Next, the law must prescribe punishment to the crime, which term as nolla quene sine lege. Next, the ex post facto law forbids making conduct criminal retroactive. effectively. Let's move on to the Latin maxims. First, we have the accessorius. One who is an accessory to the crime cannot be guilty of a more serious crime than the principal. It shows that someone aiding in or contributing the commission or concealment of a felony. A good example is by assisting in planning or encouraging another to commit a crime. It could be an accessory before the fact, or by helping another to escape arrest or punishment, which is an accessory after the fact. Actori incumbit onus probandi. The general principle that a party who brings up a particular issue is the one who has the burden of proof. The burden of proof lies on the plaintiff. If Mr. Alpha is the complainant who filed a case against Mr. Bravo, Mr. Alpha has the obligation or has the burden of proof to provide evidence to prove Mr. Bravo's guilt. Not unless if the case is self-defense, then Mr. Bravo has the burden of proof, or the burden of proof is shifted to Mr. Bravo to convince the court that it is a self-defense. Actus non facit reum nisi means sit rea. The act does not make one guilty unless there be a criminal intent. For any act to be illegal, in nature it must be done with a guilty mind. Thus, to convict the defendant, it must be proved that the criminal act was carried out with a criminal intent. We had already mentioned the criminal mind and then the criminal intent, the actus reus and then the mens rea. Actus reus, it is the guilty deed or act. More than just guilty acts, it also includes a range of other behavior requirements defined in each criminal offense. A good example, the actus reus of theft is taking someone else's property, and the actus reus of murder is unlawfully killing another person. Amicus curiae, one who assists the court by furnishing information or advice regarding questions of law or fact. It is a friend of the court. Corpus delicti. In its original sense, the body in question refers not to a corpse, but to the body of essential facts that, taken together, prove that a crime has been committed. It is the body of the crime. Again, it does not refer to the body of the corpse, but these are the body of essential facts that can be used to prove that there is a crime committed. Damon sine injuria. It refers to damages suffered by the plaintiff, but no damage is being caused to the legal rights as there is no violation of it. It is a damage without legal injury. It is the legal injury caused to the plaintiff without any damage to the physical injury. Doli incapax. It is the incapable of crime. It refers to the presumption that a child is incapable of crime under statutory law, or when the child is aging 9 years old, it is presumed that he or she cannot possibly commit a crime. The presumption that a child cannot form mens rea as he or she does not yet have a sufficient understanding pertaining what is right and what is not right. Dormiant legis aliquanda moncom moriuntur. The laws sometimes sleep but never die. The maxim is concerned with the laws that are old and outdated, but they still exist in the legal books and acts. In simpler terms, any provision under a law can be claimed in the court irrespective of the fact that it hasn't been used for a long time because the law still exists on paper. The law exists until and unless they are repealed from the books of law. Even the law was passed or even took effect in 1990s or 1970s as long as that law was not yet repealed. Ex post facto. Used to refer to a criminal statute that punishes actions retroactively, thereby criminalizing conduct that was legal when originally performed. It is by reason of subsequent act. Habeas corpus. That you have the body. A writ requiring a person under arrest to be brought a judge or into court, especially to secure the person's release unless lawful grounds are shown for their detention. The purpose of this habeas corpus, it allows a prisoner to indicate that his or her constitutionally guaranteed rights to fair treatment in a trial have been infringed upon. Habeas corpus is part of a twofold process. In a petition for habeas corpus, a prisoner or another interested party raises doubts about the legality of his or her imprisonment. If the petition is successful in demonstrating that the imprisonment justifies an examination, a judge will issue a writ of habeas corpus. This is the order of the prisoner to be brought to court. Ignorantia facti excusat, ignorantia juris non excusat. Ignorance of fact excuses. Ignorance of law does not excuse. And some say ignorance of the law excuses no one. It is a legal principle holding a person who is unaware of a law may not escape liability for violating the law merely by being unaware of its content. It doesn't mean when Mr. Alpha is not aware on the law being implemented. Unfortunately, he violated the law. He is not exempted, but he must be liable or must be held liable. In delicto, it is at fault. Caught in the act. It is the legal term used to indicate that a criminal has been caught in the act of committing an offense. Just as when you saw instantly how Mr. Alpha killed Mr. Bravo. So, you saw what happened in flagrante delicto. Injuria non excusat injuriam. A wrong does not excuse a wrong. This means that a wrong does not justify another. If a person commits a wrong, the wrong he or she suffered will not excuse or exculpate him or her from the consequences of his or her wrongdoing. Lex prospicit non respisit. The law looks forward, not backward. The maxim depicts that laws are generally deemed or presumed not to have retroactive, not unless it is favorable to the accused and the accused is not a habitual delinquent. Malafide in bad faith. The fraudulent deception of another person, the intentional or malicious refusal to perform some duty or contractual obligation. Mala inse, bad in themselves. This refers to crimes such as murder, rape, and theft. It is wrong itself or evil itself. Not only you violated the social norms of the community or the standard norms of the community, you have also violated the word of God. Mala prohibita. Crimes prohibited. It refers to conduct that constitutes an unlawful act only by virtue of statute. These are acts that are defined and penalized by the ordinances, but opposed to conduct that is evil in of itself, which are mentioned in the Malainse. Jaywalking is not evil act, but since it is defined and penalized by the ordinance, thus considered misdemeanor. Malo animo, with evil intent. The spirit of bad intention, and act done with malice aforethought. Means rea. It is a mental element of a person's intention to commit a crime. It is the guilty state of mind. Nemo bis punitor pro iudem delicto. No one can be twice punished for the same offense. If a person is both on trial or punished for the second time, it is known as double jeopardy, which the Republic Act 7438 prohibits double jeopardy. Post mortem. It is after death. Pertaining to matters occurring death, a term generally applied to an autopsy or examination of a corpse in order to ascertain the cause of death. Prima facie, on the face of it, sufficient to establish a fact or raise a presumption unless disproved or rebutted. A good example, when wife walks in on her husband with another woman, at first glance it looks as if he is guilty of something just because of the circumstances. Someone may say at the first glance it is okay or it is just normal, but at the second glance there is already a meaning on the part of the woman or your wife. Voluntas in delictis non exitus spectator. In offenses, the intent and not the result is looked at. In an offense, it is the will and outcome is regarded. When you intend to threaten someone by throwing a stone in a crowd, but one child was hit that resulted to his death, may mitigate his imprisonment, but still liable on his act.